Our next case this morning on the record here is People of the State of Michigan versus Michelle Renee Dunn. Case number is 25-14160-FH. Appearances, please.
Make cards on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Ms. Gunn. She is with me at the table now.
Thank you. Also here, you may be seated. Also here before the court today is Mr. Brian Potter. He is the probation officer from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. We are here today for sentencing after a plea of no contest to an attempt of malicious destruction of a building with a value of $1,000 or more, but less than $20,000. Mr. Carnes, did you receive and review a copy of the PSI? And if so, do you have any amendments, corrections, or objections to make today?
Yeah, I did receive and review that. I do have an addition on CFJ 284, page 2. In the second to last paragraph, right after the sentence, but he was not there during the incident. Okay. I would like to delete the sentence, but he was not there during the incident.
Any objection to that, Mr.?
I do object to that, Your Honor. That is factually what the witness stated in his interview with the police. He wasn't there at the time of the incident.
But the witness testified under oath during the preliminary examination that he was there.
Well,
All right. What page does it say? Hold on. If I use the looks like I used People's Exhibit number 1 for the taking of the no contest plea. And where does that appear inside the unchallenged report or transcript? See, his testimony began on page 4.
Page 9, Your Honor.
9. All right, thank you. I have that in front of me.
yeah, Cody's test.
Starting at number 8.
All right, well, it's uncontested there, at least because that exhibit was admitted. Therefore, I'll strike that language.
In Your Honor, I would like to add language in its place.
All right,
To say during the preliminary hearing, Mr. Chappell testified he was outside talking to the defendants through the driver's side window. Chappell stated the defendant revved the engine, put it in gear with the vehicle, and hit the house with the vehicle.
all right. All right, they put all of that. Thank you. Any other amendments, corrections, Mr. Carnes?
No, Your Honor. Thank
All right, Mr. Harrison, same question.
I got nothing.
Allocution, oh wait, hold on. Do we have any victim impact statement being made today? I don't see anybody here from the file.
No, Your Honor.
All right, thank you very much. Allocution of Mr. Harrison.
Well, yeah, I think Mr. Carnes brings up an extremely valid point here in that the story that was told by the various witnesses varied substantially between the police report and their interviews contemporaneous to the incident and some months later when the case was subjected to a preliminary exam in the district court. I think there's a lot of things wrong with the narrative that has been formed in this case, and I understand the court's point. The preliminary exam stands in the place of the defendant creating or illustrating a factual basis to you. The story that's told in the PSI is one thing, the story that's told in the transcript is another. The bottom line is she pled guilty to attempting to malicious destruction of a building, and she takes responsibility for that. That's what happened. The other thing that I think is apparent from this situation is the chaos. This is a chaotic situation. There's a lot of moving parts. There's a lot of apparent animosity between the parties. And frankly, I think it was probably for her best interest for Michelle to extricate herself from that situation. I think the damage to the property, however major or minor is determined to be, was, dare I say, somewhat accidental in nature. I know the prosecution is working to establish that there was an intentional element here. I don't know. I don't think Michelle remembers. It was a long time ago. But I think I agree with one thing in here, that she ought to be subject to a period of probation. They're proposing 18 months. That seems a little strident to me for what actually happened here. And in light of the fact that it is a plea to an attempt, I would propose a shorter period of probation with no further jail credit for the full amount of time which she has served, which we need to adjust because this was originally scheduled for a sentencing the week of the trial. We had a visiting judge who started the trial on Monday, so she got bumped off the docket that day. Was that 1 week or 2 weeks ago?
It was January 26th.
Yeah,
was the
okay.
original sentence date.
So there's 14 or 15 more days credit that she needs to be given in determining her sentence. Thank you.
Ms. Gunn, you do have the right to make a statement if you choose to do so. Right.
Can I make a statement?
Oh.
first?
I'm sorry. Go ahead. You already talked so much earlier, Mr. Gunn.
Yeah.
As soon as you were done.
I understand.
No, it's okay. Thank you.
Your Honor, Mr. Potter believes it's 13 days that should be added. 14 days. That's what I said. So.
Oh, that's
14
right. We need to change the
to
sentence
do-
date on
Yeah.
CFJ 145, page 1, and we need to increase the sentence credit
Credit.
from 81 to 95. Copy that. Thank you. And no one's mentioned restitution. I do see that it's
Yeah.
listed, so
Yeah.
go ahead.
Your Honor, we would ask this court to set a restitution hearing in this matter. It's not agreed to.
Oh, wait a minute. Is it mentioned in the transcript?
Your Honor, the interest of justice would be served by setting this for a restitution hearing.
Okay.
I will say.
All right. Do so.
Thank
Dear-
you.
all right,
I think the recommendation is reasonable.
thank you. Ms. Gunn, anything you wish to say?
No, sir.
All right, well, I've got to make some sense here of a few things, and it's going to sound like I'm picking on, but maybe I am. If you're going to stand up and make an argument about sentencing and say that you disagree with the information in the exhibit, don't stipulate to the admissibility of the exhibit. When you do that, Mr. Harrison, and she does it based upon your advice, you are saying, I'm not going to challenge it. And then you're going to come in the courtroom and tell me, well, I don't think it's fair to rely on information that may or may not be true, even though I said I don't object to it. Don't do that. That's exactly what you did and said.
Not my intention.
Well, it should have been, it was your intention because you said it twice. By the way, it wasn't a guilty plea. She pled no contest.
No contest. That's why you
Yeah.
consider it.
So if Ms. Gunn and the defense stipulated to the statement in a transcript that later on the defense attorney wants to challenge, it's the defense attorney's fault. No one else's. Why I say now, it's why when I do a plea, I say you can't come back and challenge it because it happens. The court places the defendant on a period of probation for 12 months. I adopt the terms and conditions that are listed on CFJ 145, pages 2 and 3. I find that they're well suited for rehabilitative purposes. One moment. The court sentences the defendant to 95 days with 95 days in jail. There is a $68 state minimum fee, $130 crime victims' rights fund fee, a $300 court cost, a $300 attorney fee. Now, I'm supposed to, as of very recently, based upon the appellate courts, state the reason for the fines and costs. Well, we had a preliminary exam, transcripts were prepared, defense representation over a period of time. Therefore, the costs and attorney fees are justified. There's supervision fees of $30 a month or $60 a month if there's any electronic monitoring. All right, one moment. Because this is the defendant's first felony, I have to give a guy a range. Ms. Gunn, I'm going to explain this to you in just a second. Court sentence is 95 days to 36, no wait, to 30 months. Now, Ms. Gunn, it doesn't make sense. At least I know many Supreme Court judges will say it doesn't make sense. When you have a first time felony conviction, I have to give a range. Minimum is the 95 days and the maximum is the max allowed under the law. What's interesting is later on, if you were to ever get one, of course, we're going to think positively and say, we'll never see you again here involuntarily. Next time, I don't have to give the final range if I give you a jail sentence. I do not understand why it's there. But anyways, so even though I just said 95 days to 30 months, you're not looking at 30 months. It's just a number I have to put on a piece of paper. All right. Now you also have the right to be considered for early release from your probation if you complete all the terms and conditions by halftime, which means you pay all your fines and costs within the next 6 months. Then you don't, then I'll discharge you early. Okay. Okay. Now I also have to tell you that the fines and costs are all due within 56 days, or there's a 20% penalty. Now, if you're having difficulty paying, I will remove that penalty as long as you pay the principal amount before the end of your probation. Okay. All right. So it says that I have to automatically do it, and I do, but I also wipe it off as long as you pay it before you're released from probation. Does that make sense?
Okay. Yeah.
Okay. All right. Yes, sir.
Your Honor, I have three things. I did not hear fine, DNA, or.
Oh, wait. I forgot. I pulled away to look at DNA. Thank you. DNA, there should have been a $60 DNA fee payable to the Wexford County Sheriff Department. And I'm going to fine, but I'm going to set that restitution hearing must be set and conducted within the next 30 days. Unless there's a stipulation as to restitution.
Thank you.
Thank you. Anything else? Good. Thank you. All right, Ms. Gunn. Mr. Harrison's going to bring you 2 copies of one document. You're going to place your initials on one copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of a copy of the document. The other copy, when you put your initials on it, Mr. Harrison's going to bring that back up to you. The other copy you're going to take with you. If you choose to file an application for leave to appeal, and you want me to appoint an attorney to assist you, you will complete the bottom half of the copy that you're going to take with you. All right. If you choose not to appeal, you may simply put it in a recycle bin, whatever you want. I've been thinking about how to say this and how to advise defendants. Nothing I ever say up here is to encourage a defendant like you to waive a right. Sometimes people like to, and it's okay if they do, request an appeal. I want you to know, obviously, you're gonna be out of jail here today, and it could easily take a year and a half. So whether or not you choose to appeal, you'll be off of probation and everything by the time you appeal. So I don't care what you do. I just want you to know everything's gonna probably be done on your file within the next couple months. So whether or not you choose to appeal, again, completely up to you. But keep in mind, you already pled no contest, so, but some people do, and that's their right. I just want you to leave the courtroom going, well, yeah, it's gonna take a year and a half before they ever get to it. Not that they don't get to it, but it takes a long time. Just, if you have any questions, speak about it with your counsel. All right, Ms. Gunn, good luck. Hopefully I never see you again involuntarily. You're more welcome to come by and have coffee. Have a good evening.
Yeah, for
You may. Thank you.